You're good to go? Excellent. Okay. Well, thank you everyone very much for joining me this afternoon. Thank you for attending this announcement and briefing as I lay out what I believe are some of the boldest and most progressive changes to our Crown Lands administration system in what may be decades. The issues within Crown Lands are many and come from frustrations not just with the routine processing of standard applications. They involve trying to establish pathways to resolve complex legal title and ownership guarantees, and doing it in a way that is affordable to the people least able to afford traditional legal pathways. They come from these frustrations from centuries-old common law colliding with modern and reasonable expectations of ways to solve a problem. People have voiced their concerns that the house they live in, for example, their home, their castle, may not necessarily be viewed as theirs. Today I will present tools to change that. Recognizing that housing security is at the top of our government's priorities, I am laying out our plan to recognize better ownership, better security, and better title around previously untitled property that a person's primary residence sits upon. I'm outlining a program that will be cost-effective and reasonable in resolving previously seemingly unresolvable issues of full home and land ownership when the law of adverse possession cannot be met. We'll provide relief. We'll do so recognizing that not everyone is of the same financial means. Under this program, the primary residence program, no one will have to pay full market value for Crown land, for land owned by the Crown and land that they built their house on in good faith and in good measure, thinking it would be theirs. The Crown and the adverse possession and the statute have very specific terms around ownership. We need to accommodate, and we need to create a better direction. Seniors in receipt of the Guaranteed Income Supplement will not pay anything for the land under which their house sits other than the standard processing fees. People of modest family income up to $25,000 total in the household, will just pay 5% of the market value, and the final payment for others will be on a sliding or income-based scale. We're going to provide relief to this. So with this program, the primary residence program, we acknowledge that land ownership by an individual, by a family, where a house was built on, anytime between 1968 and October 15th of 2024. If that land, that house was a primary residence on today's date, if it was the primary home, the castle of someone in modern and in a current context, even though they do not have title to the land and cannot get title to their land through the regular adverse possession stream, we have created a pathway for them to get better title. We'll give a quit claim, and instead of charging full market value, we'll recognize that the Crown does indeed own the land under its normal statutory provisions, but let's not split a hair on that. Let's provide the land at a better than reasonable cost, and we'll make it affordable and accessible. A senior who's in receipt of the GIS, the Guaranteed Income Supplement, will pay nothing except for standard processing fees of an application. Someone of greater income capacity will pay on a sliding scale. No one, regardless of income, will pay full market value. That's an important point, and it provides a pathway for home security and for title. We also recognize that the pathways to establishing squatters' rights or long-term possession under common law and statutory means has been frustrated by the passage of time. We will introduce legislation to amend the Lands Act. We will ease the burden of evidence required by applicants by reducing the historic time period required to be captured for such a claim. Currently, it is a requirement for open, notorious, consecutive, and exclusive occupation between 1957 and 77. We will reduce that to 1967 to 77. We will also ease the burden of evidence required by reducing this historic the time period for the capture, but we will create a quick and cost-effective quasi-judicial appeal system as well, so that based on the evidence that has been put forward by an applicant in good faith, if the applicant might feel that they have not been properly heard and assessed by Crown Lands, that evidence has been interpreted incorrectly, in other words, there will be a greater oversight through a cost-effective appeal mechanism that did not previously exist. Specifically, if an applicant feels as though the evidence that they brought forward meets the test of adverse possession of Section 36, but they have been denied on an administrative basis, we are establishing a very, very forward-thinking, very effective way to have that situation reviewed. We'll establish appeal boards for Eastern, for Central, for Western and Labrador. These appeal boards will be not members of government. They will be members of the Newfoundland and Labrador Bar. There will be a chair who is a member of a lawyer who's a member of the bar. There will be a vice chair who's a member of the bar. There will be a member of the engineering or land surveyors registry, and there will be a citizens rep. So the function of this appeal board will be to hear evidence as it's been put, to determine whether or not the evidence has been heard correctly, and instead of paying $40,000 to $60,000 for a trial in quieting of titles, the application for appeal will be $500. And if the applicant is successful in having the denial overturned at appeal, that $500 will be refunded in full. So we're really moving forward on significant amendments to make this more friendly to the applicant. In a modern era, we recognize that stability must come from breaking the centuries-old cycle of undocumented land ownership and all of the ambiguity captured with adverse possession or squatters' rights. Squatters' rights will now have a defined period of 67 to 77 for each application to be reviewed, 10 less years than before, and 10 less years of evidentiary performance. There will be a limitation period for receiving an application to the Crown. That limitation period will be 5 years, 60 months. So in doing that, we create a way forward that is fair but essential. Full advance of our social and economic prosperity through land ownership, which is fairly basic. Title, consistency, and confidence. That is a root and a component of social and economic prosperity. Doing that is essential. So while other provinces have basically disavowed all squatters' rights against the Crown or have evidentiary periods or exemption periods that measure into 60-year cycle and 40-year cycle, ours will be 10. I'm not stopping here. So today I'm also advising of a much more streamlined application and approval process. That includes everything from stronger and more applicant-friendly policies and directives in assessing land tenure, easier online applications, better processes within government, such as a time-limited referral process to other government departments and agencies. And I'll just expand on that a little bit, because it really is important and causing frustrations. The Crown Lands branch of my department does send out referrals of all applications to other government departments. Obviously, transportation and infrastructure may have opinions and important points to make about an application that exists on the side of a highway, or water resources when it relates to floodplains and matters related to potable drinking water. There may be other departments that have various issues that are important in terms of assessing the department. In the past, it has been the case. In the past, those referrals have sat for many, many months without resolve. We are establishing a 30-day period in which all referrals must be communicated back to the department with opinion. If the 30-day referral is not met, we will offer to extend for no more than 7 days. At the end of the period of 5 weeks, if a referral has not been replied to, we are deeming it approved from that department and accepted, so that we can move on and get this work done. That's how we shorten regular Crown application processes. That, and with electronic applications and other means, these are the tools that make this a better process. We'll deal with those land issues that are not primary residence, cannot be adjudicated through adverse possession and squatters' rights. We will deal with other applications that people who built properties on land that is not theirs to own, cabin lots in particular, I might think, will provide an amnesty period where we won't necessarily charge the illegal occupation fee, but we will expect a regular application to be submitted. And that regular application will go through the vetting process, the referral process. We do not, you do not, I do not want cabins built in watersheds. We do not, I do not want cabins that are built in places where there are real public interest in those lands and public values. So with that said, we'll provide a gateway for those that have built properties and sat on land and cannot prove any possible exemption to their squat, to their sitting on the land through either the primary residential policy or through adverse possession. Let's give them an opportunity to buy the land, same as everyone else. And with that said, with those cases where the rules are not enforced or abided by, we'll streamline the enforcement process. Instead of having all matters referred to the courts through court referral, we'll have a ticketing. We'll have a ticketing process which does streamline and get effective action to get everyone following the rules as they exist. So with that said, that in a nutshell is this presentation. Some of these resolutions, some of these solutions, you have never heard before. I've been a legislator for 29 years. I'm not a litigator. I depend on those who understand the law to give me guidance. I want to acknowledge with deep respect members of the Newfoundland and Labrador Bar, such as Mr. Greg French of Clarenville, members of the Law Society, the leadership within the Law Society of Newfoundland and Labrador, the members of the Canadian Bar Association of Newfoundland and Labrador, members of the professional land surveyors, the Association of Newfoundland Land Surveyors, who have provided certain elements of direction to all of this. It is really, really important that we understand that there are solutions to problems. There are confounding issues that are vested in common law and centuries-old law and statutory requirements, and there is an expectation that the Crown lands are a public resource. They're owned by everyone, and the public has a right to receive a benefit from that publicly owned resource, Crown lands. So the solutions that I proposed here, you have never heard of this appeal process that I'm aware of. That is something that in my time, I'm now 92 days in sitting as the minister responsible for Crown lands. I was appointed on July 18th, I think. It's now been 92 days, and I want to bring forward solutions that I know are practical, real, and will make a difference. I acknowledge that if this were easy, this would have been done 50 plus years ago. There are no solutions for everyone, but there are practical, meaningful solutions for people who need the benefit of an answer to their home ownership, to their property ownership, and to their ability to stay within the confines of the law, while at the same time recognizing they have a family and a historical right to property. Let's provide a way to balance all of those measures. And with that said, there are other formats that we'll bring forward. I won't This is a lot to digest at this point in time, but this is a very, very complete package. There will be consideration of amendments to the Quieting of Titles Act. For example, right now, under the Quieting of Titles Act, there's a two-part trial that occurs. If the trial or an application to quieting of titles as the ultimate way to resolve title issues and ownership issues, if an application is not contested by anyone, including the Crown, let's shorten the process and make this more affordable and less expensive by saying that if an applicant files for a quieting of titles, it's published within over a period of time, a limiting period. No contestant comes forward to contest that application, then there's reasonable expectation that the applicant is the true owner of the property. Quieting of titles, in my opinion, was not meant to prove perfect title pre-existed. It was actually, its purpose was to acknowledge that imperfect title existed, but there was a way to create it perfect. And in my conversations with Mr. Greg French, he was the one who convinced me of this point. So I'd like to work further on that issue. There are also issues where we know, or circumstances where we know that the Crown has been totally dispossessed. Town of areas of certain municipalities that have been towns for decades and decades and decades. There are areas within the town boundary that can be carved out as saying it is clear the Crown has been dispossessed within a certain section of, say, the town of Bonavista. I'll use that reference very deliberately. That's a historic town and a legacy town. It is clear that the town elements within the town boundary, within the planning zone, has been dispossessed. The Crown will issue a certificate, not for the entire planning district, but for those areas where clearly the Crown has been dispossessed. So this is very, very bold. This is about common sense meeting common law with common practicality meeting a common good. This is about Crown lands for the future. There has never been, or I don't think, a suggestion of a quasi-judicial appeal board, nor has there been suggestions of solving the intractable problem of primary housing ownership. These are solutions that make that come alive and ease the burden and allow greater confidence and security for those who it affects. With that said, I'll take any questions, noting that this is an elephant that has to be digested one mouthful at a time.
The legislative amendments that you had mentioned, will those be introduced this fall?
Yes, they will.
I think I know what you mean when you say that the Crown has been dispossessed of land in certain communities. Could you spell it out, though?
Yes, absolutely. So under law, the common law principle, but the statutory principle is that adverse possession exists where someone occupies a piece of land. They do so against the true owner. They occupy it openly, notoriously, consecutively, and exclusively. The 4 tests. That's common law. That's consistent right across the country and across the Commonwealth, I think. So with that said, if someone sits on a piece of land and excludes the original owner, the true owner, they gain ownership. And that's true. Many people would be unaware that that's true of private interaction. A citizen can occupy another individual's property, and they do so for a statutory period of 10 years, I believe it is, for 10 years, and then they can become the true owner. They could become the new owner. So with adverse possession, the principle behind adverse possession is if somebody sits on land, and they do so within the context of open, notorious, exclusive, and consecutive, the Crown loses its ownership of it. It has to be based on, there's good jurisprudence on all of this to describe how this is done. It's not done haphazardly or, effortlessly, but that is what adverse possession is. And so when we consider the fact that for primary residence, if somebody built a home on a piece of property that was not occupied in 1967, so in other words, that entire duration of the statutory adverse possessionary period, the exclusionary period from the abolition of squatters' rights of adverse possession. If you can't meet that full 10-year test, you're not eligible for adverse possession, which is what circumstances that many people find themselves in. They felt as though they were building on family land, on land that their family owned, but the law says differently. We need to kind of resolve that, and that's where the primary residence policy comes in place. If somebody built a house, somebody built a house on land that they felt they owned in 1984, and through the succession of conveyance or just we're not concerned about the succession of conveyance. What we're concerned about is if that house is occupied today as a primary residence, the land that it sits on should be given a quit claim, which means the Crown acknowledges it is not the true owner of that property anymore.
But there are instances where people are on land in communities that they can't claim. So does that mean that the province that the Crown will claim them back? Take them back?
So if there's instances, if the person built a home on a piece of property a year ago on land that they felt was theirs within the boundary of a community, we will offer them a quick claim at an exceptionally reasonable rate. So the Crown will not go after them. In the 77, if you look at the the Lands Act review in 2015, and if you look at the recommendations and what the government of that day followed, they said that adverse possession, the rules around adverse possession should not change. It should stay from 1957 to 77. And that's what they follow. It is, if you can't meet the adverse possession test, too bad. We don't agree with that. So that's why we're creating this secondary pathway outside of adverse possession. The second thing that they said in 2015, the previous administration, under their their Lands Act review, was that enforcement. If someone does not meet the adverse possession test, drive them out. We don't agree with that. So that's why we're creating pathways to resolve these, what are somewhat intractable issues. We're trying to create sense and sensibility to them. Common good, under common law, under common practice, for a way to resolve this.
The new rules that are being brought in around, for example, cost, do they apply to applications that are currently before the province, or is this just for new applications that are coming in?
We would love to solve all problems, and one of the issues that we've always faced is that the reason why there has been no movement on Crown lands, the Peckford administration didn't do it, the Wells administration didn't do it, the Tobin administration, so on and so forth, is that there has been a feeling, in my opinion, that unless you could solve everybody's problem, solve nobody's problem. And that's really been sort of the history of Crown lands and adverse possession. So what we're saying is we cannot reverse the past, we can simply go forward. So applications that come forward, that come in on a go-forward basis will apply to these current set of amendments as the legislation passes. October 15th is an important date.
Question for you, somewhere along the lines, not sure if I got it correctly, you had mentioned a 5-year limitation on bringing forth a claim. Does that mean from this time forward, you only have 5 years to bring a claim between 67 and 77?
That would be correct. We've announced this policy today. We will amend the policy, amend the statute, because the statute does need to be, section 36, you could advise me, section 36.2, I believe, defines the exemption period. So we'll bring that forward with full knowledge of today's announcement.
So 6 years from now, if somebody tries to bring forth an adverse claim, it wouldn't be successful.
Against the Crown. And there is a reason. One of the reasons why we are in this pickle, I think you'll understand, is that the legislature in 1976, when they brought in, they moved the statutory period, the exemption period, from a 60-year period to a 20-year period. That was the revision to the Lands Act it was the Crown Lands Act at the time, in 1967. What they said was, instead of a 60-year period, from 1957 to 77. That will be the new period, 20 years. We're moving it from 57 to 77 to 67 to 77. And when the legislature debated this and resolved and came to a conclusion on this, it is important to recognize that the purpose in 1976 was to abolish adverse possession. And I'll characterize it this way. Squatters' rights died when the affidavits died. That was the whole purpose. That was the thinking of the legislature. If your affidavits, the people who could supply an affidavit to long-term possession, were no longer able to do so because, if you think through, knowing if a 20-year-old knew the circumstance of a property in 1957, and they were well informed enough to be able to sign an affidavit to that effect, that they were 18 years old or 20 years old in 1957, because that's what would be required, how old is that affidavit today? And so that's why we're switching this so that the pool of affidavits will grow. So by making it from 67 to 77, there's now there's a likelihood, a reasonable opportunity for someone to have known the full extent of whether or not the property was openly, notoriously, exclusively, and continuously occupied from 1967 to 77. But there was always an intent by the legislature to extinguish adverse possession against the Crown. It's just that it never happened because there was no limitation period. People just didn't act on it. That's why we're in the situation we are today. So we are acting to resolve these important issues with empathy and dignity, while at the same time acknowledging that we do have a responsibility to resolve this. Because as long as this is unresolved, there's a confidence issue in land ownership and land. And you cannot build a community, economically or socially, when you do not understand or know with confidence land tenure. That's a little bit complicated, but I hope it's kind of a brief history of sort of adverse possession. It all goes back to the Admiralty, is that when we weren't allowed to own land in Newfoundland centuries ago, this is where squatters' rights actually comes from. We weren't allowed to own it. So therefore, in order to dispossess the Crown, there's a test to it. That's the history of it.
Another question, would there now be a two-tiered quitclaim? So historically, the quitclaim would be issued when the Crown relinquished its rights, but couldn't issue a grant because they didn't know if somebody else may have an interest in it. Whereas now, the Crown are, basically the requirements for adverse possession can't be met, but the Crown are issuing a quitclaim. So it's still the same situation, they're relinquishing their rights, but not the rights of other people.
Exactly, and nobody can expect. Let me kind of map this out a little tiny bit. Your ancestors, your great-grandfather, you believed he occupied a piece of land back in the 1930s. There was a succession of possession and possessory title or possessory ownership of open, notorious, exclusive, consecutive. But today, there might be some question as to whether you're the current title holder or your cousin is. So that's why we issue quitclaims. We say out loud, the Crown doesn't own this because we've been dispossessed. We've been kicked out. But we can't tell with certainty who is the rightful owner. So we issue a quitclaim, which basically means that Crown doesn't own this, proceed. That's why the quieting of titles is also so important, because if somebody comes forward and says, I've been issued a quitclaim, but at the same time, so I'm not eligible for adverse possession. I've even availed of the quasi-judicial tribunal to try to prove that, but I'm clearly not getting a grant with adverse possession. I've been issued a quitclaim, however, which says that the Crown doesn't own it, but it doesn't say who does. That's where quieting of titles comes in and says, if you file for quieting of titles, you can resolve that by having a quick and easier trial at quieting, which is less expensive. And that's one of the things we'd like to promote.
So follow up to that, and why I asked the question is, typically in the old quitclaim process, there wouldn't be a charge on the,
No, that's,
right? Whereas now there will be,
and here's.
a tiered, cost, mind you, but.
Yeah, so thank you very kindly for that question. Because in a previous quitclaim, so we're using a quitclaim as an instrument of practicality and of value and of legal substance. So nothing changes, it's not a two-tier. But with the quitclaims of previous, it was always on the basis that we have been dispossessed. We can't sell you land that we don't own. So we have been dispossessed, so we'll just simply issue, so you don't have to buy your quitclaim, because we acknowledge we have been kicked out. The Crown, His Majesty, has been removed from ownership. So we can't sell it to you, 'cause that was something that we don't own. In the primary residence policy, the reason why we're issuing a quitclaim and still charging a fee, a nominal fee, is because we're acknowledging, everybody must acknowledge, the Crown owns the land. The Crown does own the land in this particular case. And so we're going to make it so that we do have to convey it in a public interest at a nominal value. If you're a senior citizen receiving GIS, not a penny. If you make $1 to $25,000 in your cumulative, combined income in your household, 5% of market value. And then we'll tier it along those lines. Nobody will pay full value. So that, I hope, is the answer to your question. It's not a two-tier system. It's using imagination to solve a problem. It's deploying a quitclaim for the purposes which it's fully intended, which is, we can't tell you who owns it, but we know that we don't. So in the primary residence, we feel we do own it, and so we'll issue a quitclaim. And then the quieting of titles then kicks in if you need to resolve it further. Good? Thank you.
Any other questions?
Streamlined approach, making intake and processing of regular applications of Crown lands, refining and defining the referral process, online applications, creating better consistency and policy understanding, better outreach through communications. Regular stream of Crown lands applications are improving. We're also going to improve the squatters, the intractable solutions, questions, creating better access to adverse possession, to title, clear and good title through adverse possession, creating transparency and an appeal body to be able to do that. And for those outside of the appeal process, outside of the adverse possession squatters' rights, still allowing ownership of your primary residence. Even though it was originally on Crown lands, we will make sure that you own marketable title to that property. That's it in a nutshell. Okay?
Thank you.
Thanks kindly.
Thank